5 seconds to go. Start. The three judges bench of this court has observed as under. There are other reasons justifying this classification. It is well known that for the conduct of free, fair, and orderly elections, there is need to deploy considerable police force. Permitting every person in prison also to vote would require the deployment of a much larger police force and much greater security arrangements in the conduct of elections. Apart from the resource crunch, the other constraints relating to availability of more police force and infrastructure facilities are additional factors to justify the restrictions imposed by subsection 5 of section 62. A person who is in prison as a result of his own conduct and is therefore deprived of his liberty during the period of his imprisonment cannot claim equal freedom of movement, speech, and expression with the others who are not in prison. The classification of persons in and out of prison separately is reasonable. Restriction on voting of a person in prison results automatically from his confinement as a logical consequence of imprisonment. A person not subjected to such a restriction is free to vote or not to vote depending on whether he wants to go to vote or not. Even he may choose not to go and cast his vote. In view of the restriction on movement of a prisoner, he cannot claim that he should be provided the facility to go and vote. Moreover, if the object is to keep persons with criminal background away from the election scene, a provision imposing a restriction on a prisoner to vote cannot be called unreasonable. One of the basic submissions of Shri Siddharth Agarwal is that permitting filing of nomination alone is of no use unless the person is allowed to campaign and canvass. The argument appears to be attractive but has no force. Canvassing in an election can be done in many ways, such as through newspapers, social media, pamphlets, writing letters, and it is not necessary that it should be in the physical form, such as by holding meetings and by personal contact. Permitting the petitioner to be released on interim bail for the purpose of canvassing would amount to permitting the petitioner to hold meetings and to undertake door to door canvassing. This would necessarily involve interaction of the petitioner with the people of the locality on personal basis. Since the incident mentioned in the FIR took place in the locality from where the petitioner is contesting, if the petitioner is permitted to move around freely, there is a very high possibility of his tampering with the witnesses who are or local people living in that locality alone. The argument that the petitioner is entitled to interim bail on the ground that he has suffered long incarceration for around 4 years and that despite submission of charge sheet way back on 20th June 2020 itself, the trial has not progressed and very few witnesses till date have been examined is of no assistance for the petitioner for seeking interim bail. The said argument may be appreciated better while considering the regular bail but not an interim bail which is limited only to the ground whether he should be allowed to be released temporarily for the purpose of contesting or participating in the election. This apart, the thrust of the argument is that an interim bail for canvassing is necessary for effectively contesting the election. It is well known that a person contesting election has to nurture his constituency for years together, and canvassing for 10 or 15 days would not suffice the purpose. If he has earned a good reputation and his services are recognized by the people, the canvassing in the last days would not be very material. It is also well accepted that a large number of people in the past have contested elections sitting behind the bars, and they have won without being released for the purposes of canvassing. Therefore, there is no special circumstance in the case of the petitioner to grant him interim bail for that purpose. Most of the times, the campaigning is done by the party or its workers, and if one person in the party or the leader or even the candidate is debarred from canvassing, it does not in any way affect the legal right. Reliance placed upon the decision of this court in the case of Arvind Kejriwal Supra cuts no ice inasmuch as it is distinguishable on facts. There, the petitioner was holding the post of chief minister and was the president of a national party, and therefore the court opined that he is one of the main campaigners, which is not the situation in the case at hand. It may not be out of context to mention that the petitioner is in jail not only in connection with the case at hand, that is FIR number 65 of 2020, but also in two other cases, including a PMLA case and a case arising out of FIR number 59 of 2020. In those two cases, the petitioner has not been granted bail. His bail application, interim bail application in those cases are pending in different courts, but the fact remains that he is not on bail in those two cases, meaning thereby that even if the petitioner is granted interim bail in the present case, he would not be out of prison for the purpose of canvassing and campaigning. Therefore, the entire exercise in this regard will prove to be academic and futile in nature. It is high time that the citizens of India deserve a clean India, which means clean politics as well, and for the said purpose it is necessary that people with tainted image, especially those who are in custody and had not been granted bail, and those who are under trial, even if out of jail, be restricted in some way or the other from participating in the election. The people of India should be given a choice to elect people with clean image and antecedents. In the case at hand, as stated earlier, the court is confined as to whether interim bail for the purposes of election ought to be allowed or not. The petitioner, on the ground of his long custody or the trial not being completed for long, may argue for regular bail, but that is not the subject matter for consideration before this court today. We do not intend to usurp the jurisdiction of the High Court, where the regular bail of the petitioner is pending consideration. In the facts and circumstances of the case, long incarceration of the petitioner or the fact that some of the other co-accused have been released on bail, or that upon evidence the entire case of prosecution will fall to the ground, are not relevant, and therefore I am of the opinion that the High Court has not committed any error of law in exercising its decision in refusing the interim bail to the petitioner and permitting him only custodial parole for the purposes of subscribing oath and filing of his nomination papers. In simple words, interim bail is not permissible for the purposes of contesting elections, much less for campaigning. In this view of the matter, no case is made out for any indulgence in exercise of discretionary power of this court under Article 136 of the Constitution of India, and the special leave petition is dismissed with liberty to the petitioner to pursue his regular bail application before the High Court, where he may seek an advancement of the date of hearing fixed in the matter concerned if so advised. Stop.